Some of our progressive era cases here. There's 5 of them that I'm going to ask you to know. These are all cases that you may have read about. A couple of them are the ones that were kind of optional from last week's online assignment. But there's 5 cases in total here that I want you to know dealing with our progressive era, looking at some of the various reforms that the United States tries to go about accomplishing, whether it's in the workplace or child labor, or issues involving the Sherman Antitrust Act. Okay, again, these things would be viewed as progressive initiatives, I suppose you could say. And so some cases, Congress would go about trying to pass laws. Something like the Sherman Antitrust Act would be viewed as a progressive law. And then you see various challenges to those laws. And as a result of the challenges to said laws, we have Supreme Court cases where ultimately the Supreme Court has to come in and make a decision as to what is what. Okay, so the first of the cases I want you to know, this is one that you would have read about last week on Friday, is the Northern Securities Company versus the United States in 1904. So 1904, that is still during the era of a Teddy Roosevelt presidency, right? Teddy Roosevelt was a trust buster, so to speak, trying to break up some of these big companies. And for these cases, the big thing to understand is kind of like what it was all about and ultimately how the Supreme Court rules. We're not going to spend a lot of time on any one of these cases, but knowing the issue and the outcome would be the most important thing. So the background on Northern Securities Company is Northern Securities Company was a trust, so to speak. And as a part of their business holdings, they owned 2 railroads. And 2 of those railroads, they were connected to the Pacific Northwest United States, thinking present-day Oregon, present-day Washington. And these 2 rail lines that were owned by the Northern Securities Company ran from the Great Lakes and from the Mississippi River out all the way to the Pacific Northwest. And so what you start seeing happen is people in the Pacific Northwest, whether they were business owners or just everyday normal consumers, is they were kind of at the mercy, so to speak, of the Northern Securities Company for the cost of freight getting to the Pacific Northwest. The cost of that freight then would ultimately dictate price. And there is a challenge that Northern Securities, under the Sherman Antitrust Act, is going to have an illegal monopoly, an illegal trust, because they are literally controlling the market in the Pacific Northwest. And so the question that the Supreme Court ultimately has to answer is, was there authority by Congress under this Sherman Antitrust Act to regulate the competition and such associated with the freight costs and such? Because again, the Northern Securities Company, they didn't have any competition. They own the 2 rail lines running in the Pacific Northwest. So in this case of the Northern Securities Company versus the United States, ultimately how the court is going to rule is that these 2 railroads in fact did have an illegal monopoly, because the fact that they were the only 2 railroads that were running into this area of the United States, it did not allow for any competition. And so this is one of these trust-busting cases ultimately that it's going to allow enforcement of the Sherman Antitrust Act, that the Northern Securities Company had to break up their railroad or had to break up their business, allowing for more competition to flow into the Pacific Northwest. So when we look at, ultimately answer the question is this case a win for progressivism? We would say that in the case of the Northern Securities Company versus the United States, that this gave the government more power to control the railroad industry, which, for a long time we've talked, they kind of ran rampant, right? They had a lot of power and a lot of influence, a lot of money. And so when it came to the Sherman Antitrust Act, this is a case that's viewed ultimately as a win for the Sherman Antitrust Act being enforced. And this is viewed as a win for progressivism in the sense that we are now finally allowing, 25 or 15 years later since the passage of the Sherman Antitrust Act, that we're now finally allowing for the enforcement of said law. So Northern Securities Company versus the United States involves railroads, involves monopolies, and ultimately the question of, can we enforce the Sherman Antitrust Act to break up this Northern Securities Company? And the outcome of this case, Supreme Court's going to rule against Northern Securities Company. They're going to rule in favor of the United States. And this is going to be viewed as a win for progressivism in the sense that we can now finally enforce the Sherman Antitrust Act. Okay, so that's 1904. The other Sherman Antitrust Act case that I want you to know about involves John D. Rockefeller's business, Standard Oil. This is a case from from I believe it's from 1911. Oh, there it is. Okay, from 1911. So again, we're still talking right around the time of Teddy Roosevelt's presidency. Again, very well known that John D. Rockefeller, Standard Oil, was perhaps the best example of what a monopoly was in the United States at the time, and how he operated his business. And so this is another question where finally in 1911, how many ever years after the formation of Standard Oil, where the Sherman Antitrust Act is now finally going to apply to Standard Oil. Standard Oil ultimately is going to be forced to break up its business a little bit as a result of this Standard Oil case. So the Standard Oil case, that's another one where we would view this as a win, so to speak, for progressivism, in the sense that we are now finally again enforcing the Sherman Antitrust Act and bringing down the end of the reign, so to speak, for Standard Oil and John D. Rockefeller. So again, our first two cases here involve the railroads, and then we also talk about Standard Oil. Both of these cases are viewed as wins for progressivism in the sense that we are enforcing the Sherman Antitrust Act. The other three cases that we look at then with the time period involve labor of some sort, okay? Ultimately workers' rights, child labor, working hours, that type of thing. So our first of those cases is going to be Lochner versus New York. And so this is, again, a Teddy Roosevelt era case. This one doesn't, or this one, I guess, goes over about as well, or not as well, I should say, for progressivism. So this involved workers in a bake shop, okay? And ultimately, there had been a New York law passed that basically said that if you work in a bakery or in a bake shop, you're making baked goods, whether it's banana bars or bread or cakes, whatever it might be. There was a New York law in the books that basically regulated how much workers could work. It was like 10 hours a day and a maximum of 6 days a week. Well, this Mr. Lochner, who owned a said bake shop, he received a fine for allowing an employee to work more than the number of hours allowed by this New York law. And so he gets a fine, and I know you're probably going to laugh when I say this. It was like a $25 fine. Okay, it's like a speeding ticket in North Dakota. I know, but at the time, think early 1900s, $25 is probably worth a little bit more. And so ultimately, Mr. Lochner challenges the constitutionality of this New York law. Eventually, it gets brought to the Supreme Court, and this case does not go over as well. For progressivism. The Supreme Court is ultimately going to rule in favor of Mr. Lochner. They're going to rule that this New York law, it violated it was like negotiation rights of workers, and the state of New York, who said that we have a police power to limit these bakeries, to limit these bake shops. The Supreme Court doesn't see it that way. Okay, and so this case is ultimately viewed as a loss, so to speak, for progressivism. Now, again, this is early on. Eventually, this ruling is going to be overturned, I should say, by a different Supreme Court ruling that we'll talk about here next. But so Lochner versus New York, not a win for progressivism, but later on the case will be overruled in a different case. So again, Lochner versus New York, it involves working hours, working days. Can the state pass a law ultimately that would limit or place a cap on how many hours or how many days a week a worker could work? And the Supreme Court's going to say, state of New York, we think this is a reach. This law does not allow workers, cannot interfere with the contract between a worker and employer. And so ultimately this is viewed as not so much of a great outcome for progressivism. But not so long after Lochner, there is another case, okay? And this now, again, is a similar situation. This is involving a Mr. Mueller, in the state of Oregon. And so the state of Oregon had passed a law similar to what the state of New York had passed. Now, instead of talking about bakeries, though, we're talking about laundries, okay? Places where, we have fabrics and such being washed and that type of thing being cleaned. And so the state of Oregon had another law on the books. It was that workers at these various factories or laundries, they could not work more than 10 hours per day. So Mr. Mueller got in trouble. He was, again, fined because now we're talking about a female employee. He allowed her, or made her, I should say, work more than a 10-hour day. And so under this Oregon law that regulated how many hours a day these individuals could work in laundries, which I will tell you, the laundry workers were generally females, and sometimes were children as well. And so the Supreme Court is now kind of looking at the same question, or examining the same question or a similar question as to what they're going to examine, or what they examined in Lochner versus New York. But this time the Supreme Court's going to rule differently. The Supreme Court is going to rule that, hey, this Oregon law, this is a good law, that the state of Oregon had the power to place regulations on how many hours a day that women could work in these laundries. The court, I know it says here in the decision that the court ultimately is going to take into account that there was a so to speak, physical difference between men and women, and that having a law on the books limiting the number of hours in a day that a female could work, might have been more beneficial, because now you're looking at, just the biological differences between females and males. And so this ultimately creates this ultimately upholds the constitutionality of this protective legislation that regulated the number of hours that women could work. And so this kind of leads to something called the Brandeis brief, which I wouldn't necessarily say you need to know that for this, but ultimately understand that Mueller versus Oregon, it examines a similar question as Lochner versus New York, but now we're looking at working hours and days for females. And so the result of this case, we would say, is a win for progressivism, because as a result of this case, there will be other laws that are passed later, protecting child labor and some other things. So eventually some of the constitutionality behind this law gets applied to other things. So in this case, because we would say that the Mueller case ultimately is going to improve working conditions and hours and such for laundry workers, we would say that this case is viewed as a win for progressivism. Okay? All right, so those are our first 4 cases. So of our first 4 cases, we have Northern Securities being a win for progressivism. We have Mueller versus Oregon being a win for progressivism, and Standard Oil being a win for progressivism. Okay, now the last case I'm going to ask you to know for the purpose of our test is Hammer versus Dagenhart. And so Hammer versus Dagenhart, this is a little bit later on. Now we're talking 1916. So a President Roosevelt is out of office. Okay, this would be during like the Woodrow Wilson administration, I suppose. And ultimately, this case deals with child labor. Okay, so Congress had passed something called the Keating-Owen Act, under the Congress's ability to regulate interstate commerce, having to do with child labor. Okay, and that how much what ages should we be allowing kids to work, how long should we be allowing them to work, that type of thing. And so the Keating-Owen Act, which that law on its own is viewed as a win for progressivism, because it places now a limit on how many days that a child can work and when they can work and how many days they can work. But anywho, the interesting story with Hammer versus Dagenhart is, so this Mr. Dagenhart, he wanted his 14-year-old son, I believe, to be allowed to work in a textile mill. He wanted his son to be able to go and have a job and work, right? Think of the time period, right? It was not unheard of. If you were 14 years old, there's probably a chance at this time period that you're no longer in school, probably a higher chance that you're not in school than you are in school. And so the question now becomes, Mr. Dagenhart's like, well, I want my child to work. I want my boy to go to work and make money. And so under this Keating-Owen Act, his child technically could not work, okay? Because he was 14 years old, he could not work full time. And so he challenges this Keating-Owen Act, okay? I want my child to go to work. And ultimately this case, the outcome of it, it's viewed as a loss or a negative for progressivism, because the Supreme Court is going to rule in favor of this Dagenhart. Okay, now later on in history, right, we are, big theme of history is we sometimes try to right the wrongs, so to speak, I guess. And later on, I believe it'll be in the 1930s or 40s, There will be another case, and the Supreme Court will rule on that differently. But as a result of this Degenhart case, the Supreme Court says, hey, you know what, Mr. Degenhart, you're right. The federal government did not have the power to place a limitation on when your child could work. And that this, so to speak, Keating-Owing Act is unconstitutional because it's not an example of interstate commerce, okay? However, later in time, child labor laws, when new ones get written later in history, there will be a tie back to school attendance and working and such, and ultimately determining that it's more important that children are in school than it is that they are working a full-time job. But Hammer versus Degenhart is viewed as a loss for progressivism because it's going to allow for more, so to speak, maybe unfair, unreasonable child labor things in the United States for a period of time until new laws are passed later and there's some more Supreme Court cases that are now going to place limitations on child labor. But I would know for the now, Hammer versus Degenhart, involving a case of child labor, how old, how long, working days that kids could work. Mr. Degenhart wanted his son to work in this textile mill. He was only 14. And the Supreme Court's going to say, you know what, if you want your child to go to work, we have to allow that. So this Keating-Owing Act is unconstitutional. So at face value, then, this case is viewed as a loss for progressivism. Okay? As far as where to find some of this information, all the info here it's in the Progressive Era folder on Schoology. That's what I'm using here for the purpose of our video. Again, we expect to test on Thursday if we are in school. If we're not in school, we will test Friday. Expect a Kahoot to be posted here later on. All right, if you have questions, you can certainly email me. Have a great day.